The Supreme Court has primarily upheld the Practice and Procedure Act. There were two core aspects of the Act, firstly relating to the practice and procedure, and secondly relating to the right of appeal. Coming to the practice and procedure aspect of the law first, this aspect of the law has been upheld by a majority of 10 judges, with 5 judges dissenting. And this part of the law created a committee of judges comprising of the Chief Justice and the 2 senior-most judges. The committee of judges will decide how benches are to be constituted and how the court's suo motu jurisdiction is to be invoked. Previously, this power vested with the Chief Justice, and through the new law, this power was given to a committee of judges. And as I said before, a majority of 10 judges have upheld this aspect of the law. In my view, this is problematic from the aspect of the separation of powers and the independence of the judiciary, because it means that the Supreme Court is subservient to Parliament when it comes to its own practice and procedure. It means that the Parliament sits over and above the Supreme Court when it comes to its practice and procedure, and that Parliament can control the internal workings of the Supreme Court. And this paves the way for further parliamentary intrusions into the Supreme Court and its internal workings. And a lot of the judges said that why should we be concerned with the future, and we're just looking at the law which is before us. The reason that the future is important is because the Supreme Court is setting down a matter of principle. And as a matter of principle, they're conceding that Parliament can regulate the internal workings of the Supreme Court. Coming to the right of appeal aspect of the law created a retrospective right of appeal, which means that decisions given prior to the commencement of the Act and past decisions can be appealed. And this aspect of the law was struck down by a majority of 8 judges, with 7 judges dissenting. And the judges have said by majority that there is no right of appeal for past decisions, and decisions given prior to the commencement of the Act cannot be appealed. However, by a majority of 9 judges, with 6 judges dissenting, the court has preserved the right of appeal for decisions given after the commencement of the Act. So the right of appeal will apply prospectively to decisions given after the commencement of the Act, but the right of appeal will not benefit and will not provide any benefit for the decisions prior to the commencement of the Act. Even on the prospective right of appeal given to decisions after the commencement of the Act, it is problematic because the Constitution does not create a right of appeal against decisions of the Supreme Court handed down under Article 184(3) of the Constitution. And if a constitutional jurisdiction is to be created, and an entirely new constitutional jurisdiction is to be created, the only way this can be done is through a constitutional amendment and a 2/3 majority. It cannot have been done through ordinary legislation. And often even a good thing done by an authority which was not competent to do it leads to more problems than it solves.